We will wait for two. We will wait for 2 more seconds. Let everybody join. A very good afternoon to everyone present here. This is Ipshita Goyal, Senior Executive and Editor in Chief at Legal Thirst. Today, we all are gathered here to attend an insightful session on Apprentice of Evidence in Criminal Trial by Justice Subodh Shah. Former Justice Subodh Shah got enrolled as an advocate in 1981 at Mehsana, Gujarat, and continued his practice as an advocate till February 1997. During this period, he practiced almost on all sides like civil, constitutional, revenue, etc., in various courts, tribunals, and commissions. In March 1997, he was directly appointed as a judge of the City Civil and Sessions Court, Ahmedabad, by invitation. He was sent to the Honorable Supreme Court of India for classification of cases of Supreme Court in May 1997. In 2006, he was appointed as Registrar, Courts and Computers, Supreme Court of India on deputation. He was also appointed as Special Judge, CBI Court, Ahmedabad. He was appointed as a member of Standing Committee, Supreme Court. He was elevated as additional judge in Gujarat High Court in November 2012. As a judge of High Court, he delivered approximately 19,832 judgments in just uh, 1,260 days. This is long list of achievements in a short span of time. It's truly fascinating, sir. We invite you, sir. In today's session, Apprentice of Evidence in Criminal Trial, we will learn about the Indian Evidence Act and some key points on evidence in criminal trial. It is said and believed that appreciation of evidence is the heart and soul of the dispensation of justice delivery system in criminal law. Sir, now the dice is yours. Kindly enlighten us with your words and thoughts.
Good afternoon, everyone. I hope I am audible. Hello.
Yes, sir, you are
Yeah.
audible.
Okay, then I may start.
Yes, sir.
Yeah. Good afternoon, everyone. It's a hot day in Ahmedabad. Uh, we'll start with a slideshow.
Yes, sir, you can start now.
Sure. Is it visible?
Yes, sir.
Yes,
Okay.
sir.
Yeah. Thank you. So we will start the subject. But before starting the subject, I will like to make it clear that most of these sentences or texts or phrases or details are taken from the judgments of Supreme Court of India or other high courts. So the language or the text or the meaning, because generally we have to follow the judgments of Supreme Court and High Court. So instead of taking everyone, yeah. instead of taking different language, I have taken care of selecting the phrases from the judgments only, because ultimately it is judgments of Supreme Court and High Court which decides the law, which makes the law, and which is to be followed by other courts. So what I say or what you understand or what you are saying or what other understand is not material, but what is said by Supreme Court or High Court in their judgment, that is the material phrases or sentences, and therefore language used in this lecture or in this slideshow is practically taken from some judgments only. This is one thing. The another thing is, see, appreciation of evidence or any law is not a static. It may change. So what is good on yesterday may not be good today, and what is good today may not be good for tomorrow also. So it is always a changing situation. So as and when we have to apply some law to the pending case or live case, we have to take care of legal position and situation on hand at that point of time. Before starting the subject, I would like to share with you few principles of our day-to-day life, some knowledgeable phrases. Never underestimate your competitor. It may be in any form, particularly for lawyer, it may be other side or a witness or anybody. So never underestimate your competitor. Try your best. Expect the unexpected. Anything can happen at any point of time, or something may come unexpected at any point of time. So expect the unexpected. And always think there must be a better way. Think out of box. Everything may be new or first time, it may be first time at every point of time. So though we have to follow the precedents by the High Court and Supreme Court, many a times those precedents are there only because somebody has pleaded or argued before the court. So think there must be a better way. Don't rely upon something which is not good. We cannot direct the wind, but we can adjust our sails. All these lessons are equally applicable for appreciation of law or considering law, and therefore I have selected it. So if something is not in our favor, we cannot direct the wind, but then we have to adjust ourselves, sails. And always be speedy. React now. Time, tide, and opportunity waits for none. If you want happiness for a lifetime, learn to love what you do. So if you are an advocate, don't think that why I am an advocate. Or if you are a witness, don't worry why you are a witness. So do whatever is best in your life. One man makes difference, and you may be that one man. And best way to make your dream come true is to wake up. Whatever you want to do it at the earliest, immediately. Because again, I am repeating it, react now, time, tide, and opportunity waits for none. Now, coming to the point or the subject, appreciation of evidence. See, evidence, I will explain what is evidence, but evidence alone is not sufficient. Either it is a criminal trial or even a civil trial. But so far as criminal trial is concerned, it is more serious. Appreciation of evidence is more a serious issue than any other thing. Many a times, knowledge is considered as an evidence, but knowledge alone is not enough. I will give you one example. A person is going to the court or a police officer or somebody and wants to lodge a complaint or FIR regarding murder. Now, if you want to lodge a complaint about murder, what is basic requirement? Your complaint, your statement must disclose the death of a human being. If you don't disclose that who is killed, then there is no case of murder. So what is material or appreciation is death of human being. disclosure or fact regarding death of human being. This consideration is appreciation of evidence. And in similarly, in the same FIR or for the same complaint, if you don't disclose the place or where the dead body of that person is lying or available or where it is, then also it is uncertain that whether that person is live or dead. So unless there is a disclosure regarding existence of a dead body at a particular place, and manner, if manner is not known, but the fact that he is killed, he is not died by natural death. These basic facts are considered as appreciation of evidence if there is an FIR of murder. Otherwise, if you say anything to the police, police has to select the section for framing charge against the accused. And then police may find out it after investigation. But it would then again rest at the end of the police. So unless you disclose proper facts to the investigating agency, there may not be a proper FIR or complaint. And that proper facts depends upon the actual offense or issue between the parties. So if offense is regarding killing, death of a human being, there must be a disclosure of human being and existence of dead body at some place. I have reason to say so because if you people have read the newspaper, recently it has happened that police has charge sheeted 2 persons for the death of one human being. And you will surprised to note it that when matter was listed for hearing, recording of evidence, though dead body of a person was there, it was identified by local persons, but at the time of recording of evidence, somebody has found out that this person has in fact traveled to his native place in other state. And it was inquired by somebody, some witness or somebody, and the person for whose death 2 persons were charge sheeted, he was found in his native place. He was called and then it was said that he is alive. It is true that somebody was died at the place of incident. It is true that there was dead body, but there was no proper identification of that body, and therefore 2 persons were charge sheeted for killing X because they were residing together in the same room. But ultimately it was found that that third person was alive, but it was simply a fact that he went away or run away to his native place because of some other reasons. So appreciation of evidence is what is the fact is not material, or what is the story is not material, but what is actual evidence which proves the commission of particular act, which may be considered as an offense, or in civil matter, which proves the right of a particular person. That consideration of evidence is called appreciation of evidence. Thus, appreciation of evidence is a matter of experience and knowledge of human offense. It is a delicate task to be carried out by judges for weighing evidence and drawing inferences. Each case presents its own peculiarities. Common sense and skill are also part of the tools. Appreciation of evidence is a term used in Indian law to refer to the consideration or examination of evidence by the court. It involves weighing the credibility and reliability of the evidence presented in the case. So generally, evidence is to be produced before the court and it is to be appreciated by the court. But when court can appreciate it, when it is properly proved before the court. So before court can appreciate it, it is for the parties to appreciate it properly, to identify it properly, and then to prove it properly before the court. Because law is basically logic or concept based upon culture, social and geographical necessities and social values. Though it is codified, it is not static. So the interpretation of law and thus appreciation of evidence would also not remain static forever. Appreciation of evidence is both art and science. It is art because it is a skill acquired by continuous practice and through real-time experiences of an individual. Whereas it is science because it is a systematic approach adopted as per basic scientific proposition. So far as legal system is concerned, it is adoption of systematic approach under the governance of certain rules framed either by the legislature or under the due adherence of the court's verdicts. So the law is not static, and though appreciation of evidence is science, I have already said, since it is an art, it would differ from person to person, judge to judge, court to court. And therefore, one judge may appreciate particular evidence in particular manner, whereas other judge may appreciate it in different manner. And to some extent, it is typical science, as it is to be decided, appreciated based upon the rules framed by the statute or by the judgments of the courts. And what is the difference between appreciation and evidence? Or not only difference, but what is the understanding of appreciation and evidence? It is a different term, different terminology. Appreciation is defined according to Black's Law Dictionary. Appreciation means to know or to understand or to realize. Unlike normal English usage, which means admiration, the word appreciation must, for all purposes, is a distinct word in the legal application or rather sense. Therefore, appreciation of evidence is not a general term used in a normal language. In day-to-day language, we use the word appreciation for a different purpose and in a different manner. Just to admire something, we say that I appreciate you. But so far as law is concerned, appreciation means it is not only admiration of that evidence, but appreciation means it is to know and to understand and to realize that what is evidence. If time permits, I will give you one or two more live example of few cases. But let us go further to few conceptual slides first. Then what is evidence? Evidence, as per Tomlin's Law Dictionary, means an inference logically drawn as to the existence of a fact. It consists of proof by testimony of witness on oath or by writing or records. The key words in the said context refers to inference, to be drawn logically, means that by use of reasoning, conclusion or derivatives must be drawn. It seems to be a complex definition or something in complex terminology. That evidence is evidence. Something is produced before the court, a copy of FIR, copy of postmortem note, any document, some physical evidence also, weapon, rifle, gun, pistol, revolver, knife,
Sir,
stick.
your screen is not visible. Kindly share your screen.
Screen is not visible.
No, sir.
Previous screen was visible.
Yes, sir. Earlier it was visible.
Oh, but it is stopped from your end. You are not allowed to share your screen. You have to make me host or share it from
Sir,
your end.
now,
You
sir,
have make
try
it.
now.
Yeah, you have made it now. I'm starting it. I'm starting it again. No, but yeah. Is it now? Is it visible? Is
Yes,
it
sir.
visible?
Now it is
Yes,
visible.
sir. Yes, sir.
Yes, sir.
Visible.
Okay, okay. So just simply make it sure that there is no change from your end, or as a host. Anyway, so evidence is a simple terminology in legal word. That evidence means copy of FIR, copy of postmortem note, copy of any document, or any weapon, physical evidence, or something, or a deposition of a witness. But that is only a physical evidence. Now, appreciation of evidence, as I said, that if there is an FIR, that I am filing a complaint against X for killing Y. But within that FIR, if there is no disclosure, proper disclosure regarding death, actual death, and existence of dead body, it may not be a complaint under Section 302 of IPC. It may be simple a disclosure of some fact by a complainant before the investigating officer, and then investigating officer has to verify everything. He has to find out the dead body. Now, question is, once dead body is found out, see, if in complaint I don't disclose the nature or reason of incident or cause of death or something, it is true that it may not be known to complainant. But if there is no disclosure and thereafter it is found that person is died by natural death, either found or with due respect to the all agencies, if agency does not find out proper evidence and simply say that it is a natural death, then there is a difficulty. At that point of time, postmortem note is another piece of evidence. Now, again, there is a chance if there is no disclosure that somebody is died by weapon or poison or by particular manner or reason or something is not disclosed properly in a FIR, then there is chance that during investigation it may be found out, rightly or wrongly, God knows, but it may be brought before the court that death is natural or for some other reason, and therefore the FIR on day one, which was an FIR by the complainant for murder, becomes a simple piece of paper regarding disclosure of some mishap only. So this is appreciation of evidence, that what is to be disclosed or what is to be read from particular document or evidence or deposition of particular witness. In past, I tell you, because we have to consider this subject mainly because of this reason, that in past, the acquittal ratio was very high. The reason behind it was that most of the witnesses, when coming to the court during those days, depositions were recorded in English throughout India, most probably throughout India, wherein a single sentence was stated by the witness and recorded by the court. What do you know? I saw nothing, I know nothing. I've seen nothing, I don't know anything. मैंने कुछ देखा नहीं, मुझे कुछ पता नहीं. This single sentence and by most of the witnesses, and then there would be acquittal. So what witness has stated before the police and what he's stating before the court on oath, testimony of witness on oath. Now, what is disclosed on oath before the court is an evidence, and it is an appreciation of evidence that what witness has said before the court is to be relied upon, and not what police has recorded in his name in his statement, which is generally not required to be signed by him in most of the statute. Now, by passage of time, there are certain statutes where statement of witness are required to be signed by him, and he is not allowed to say different than what is recorded in his statement. But it is a different story. But as on date, our constitutional requirement is such that investigating agency could not take signature of a witness, and witness will turn hostile before the court, not supporting their own case. It is altogether a different story that many a times investigating officer does not record proper statement. But so therefore, this is appreciation. What is evidence and appreciation of evidence? Mere disclosure is not enough. There must be evidence before the court on oath, and contents of documents are equally relevant. If we continue with the same example, even after FIR or disclosure of murder by some weapon, in post-mortem note, if it is found that poison it was given to the victim and there was no injury on his body, then it would be an appreciation of evidence that FIR is not correct, though there is a death of a human being. But cause of death is different, therefore the reason for death may be different, therefore whether there was a killing or murder or not, it is to be decided by the court. Evidence Act defines the word evidence. According to Section 3 of the Indian Evidence Act, evidence means and includes all statements which the court permits or required to be made before it by witness in relation to matters of fact under inquiry. Such statements are called material evidence. And all documents, including electronic records, produced for the inspection of the court, such documents are called documentary evidence. So now it is in simple words that any statement by a witness is a material evidence, and any document is a material documentary evidence before the court. But production of evidence before a court is a simple thing, whereas appreciation of that document or that deposition of witness is a complex thing, and it is called appreciation of evidence. And decision of any case depends upon such appreciation rather than production of document or disclosure of document or evidence. So it is a pictorial facts of definition of evidence, oral evidence and documentary evidence, so that we can distinguish it and identify all statements which are permitted by court as oral evidence, and all other document including electronic record are documentary evidence. Thus, evidence determines how the parties convince the court about the existence of facts. According to the provision of the substantive law, which would establish the existence of rights, liability, or disability and in civil matters, whereas involvement or innocence in criminal matter, which they assert to prove or deny in the proceeding. So, any fact which confirm anything, either rights, liability, or disability, so far as civil disputes are concerned, or involvement or innocence so far as criminal matters are concerned. And if such fact is assert or prove or deny, means disprove the same, then it is called a proper evidence, and it is to be appreciated by the court. Simple piece of paper or simple weapon or simple fact or simple statement, it may be an evidence, but on appreciation, if it doesn't prove anything to decide the issue which is before the court, then that piece of paper or that physical or other evidence is of no use. And this process, that whether this evidence is capable to prove anything or disprove anything, that process is called appreciation of evidence. It is well known that proof is the fact or result of evidence, while evidence is the medium of proof. It is in a simple language that evidence is a medium of proof, and proof is actually evidence to decide something, and whether any evidence proves anything or not, whether any evidence has any proof of particular issue or point before the court, that process, that consideration is appreciation of evidence, because appreciation of evidence is not a physical thing. It is art, it is a science, it is a concept. The significance of appreciation of evidence in legal proceedings is like a dawns in the dispensation of justice. The judge has to consider the testimony, both oral and documentary, in order to conclude without bias on the system of reasoning, so as to anchor the facts of harbor of truth, in order to demonstrate, make it clear, or to ascertain the truth of very fact or point in issue on either side. In one of the judgments, Supreme Court has tried to explain that what is appreciation of evidence in these wordings, and signifies it that appreciation of evidence means first thing, court has to find out the truth and nothing but the truth. And therefore, if some fact, some details, if it gathers a knowledge, understanding during the judicial proceeding about particular fact, very fact, or about the particular issue on either side, because court's duty is to consider it the truth only, whether it is in favor of the petitioner or respondent, that is complainant or accused, it is immaterial for the court. So court has to decide that whether particular fact brought before the court proves anything in favor of the complainant and against the accused, or in favor of the accused and against the complainant. That process is called appreciation of evidence. Appreciation of evidence is one of the foremost tests to consider credential of the evidence brought by the parties in a proceeding, who propounds their respective theory of rights, liability, or disability in civil matters and in criminal proceedings, either involvement in commission of crime or innocence. So as I said earlier, it is appreciation of evidence is the foremost test to consider that what is brought before the court, what is proved before the court, and what is the outcome of such knowledge or understanding. That outcome is whether there is a involvement in commission of crime by the accused or his innocence. That is to be taken care of by the court by appreciating the evidence. So practically, judging or deciding a case is solely based on appreciation of evidence, and appreciation of evidence is based upon, as I earlier said, some statute, because Evidence Act provides how to appreciate the evidence. Some other acts also provides it. And in some cases, Supreme Court's and High Court's judgments explains that how particular evidence is to be considered or appreciated properly. And what is the basic concept of appreciating, marshalling and appreciation of evidence? What is to be considered to appreciate the evidence? The marshalling of evidence is not the repetition of what a witness said, but the critical grouping together of the relevant statements of particular witnesses for and against a particular fact. It is the skill of picking up various pieces of evidence on a particular disputed point and putting them together. A judge must have clear picture of various disputed points regarding which the evidence has to be marshaled. Appreciation of evidence means assessing the worth, value, and quality of a particular piece of evidence. So what is required, or what is the concept or basic idea regarding appreciation of evidence? Mere repetition is not required. There is a story of a man and tiger. You may be aware or not, but in Panchatantra there is a story that one man, while going to graze the cattle, goats, every day he used to shout, tiger came, means bhag aaya. And people of the village gets together to help him. And then he was laughing that look, there is no tiger. After a couple of days, few wise people has advised him that look, if you do it on daily basis, then probably people will stop to come to for your help. And the day when actual tiger comes to near you, there will be no one to rescue you. The story is in negative sense so far as my explanation is concerned. That is, if you do something repeatedly, it will lose its image. Similarly, in criminal trial, that repetition does not pay. The repetition of same story by different witnesses does not prove particular thing properly. No doubt there is a need of supporting evidence. But number of witnesses are not material. What they depose before the court about particular issue, point, or incident is material. If there are more witnesses of the same incident, there would be more contradictions. At the same time, single witness is also not good. If there is supporting evidence, it is better. But then it may be 2 or 3, but not 20 or 30 or 15. So marshalling evidence is not repetition of what witness said, but the critical grouping together of the relevant statement of particular witnesses for and against a particular fact. So repetition is not material, but now what is required? Grouping critical information from different eyewitnesses, means oral witnesses, oral depositions of persons, witnesses. So also with the documentary and other evidence. I will give you one example of one case. Since it is a one-sided lecture, I am audible, na?
Yes, sir.
Hello? Yeah.
Yes, sir, you are.
Okay, then fine. See, I will give you one example that in a given case, a person was taken away by a group of people, 4, 5 or 6, 3, 4, 5 people from one place in a vehicle. They beaten him to certain extent and then he dropped him to some other place, maybe 5, 10, 15 kilometers away. Now, after coming back to his point, see now what is actual appreciation of evidence you will realize from this example. The basic fact is he was temporarily kidnapped from one place to another place for 10, 15 or 25 kilometers and he was beaten. Now, that beating was not so serious. It was the case of 323 or 324 of IPC, means hurt and grievous hurt, means some slaps or some stroke by hand or feet and lathi. And at the most there are some abrasions on body, but there was no fracture. There was no danger of death of a man because of any of such injuries. So there was no case of 307, but it was a case of 323 and 324 of IPC. Simple and serious injuries, not grievous injuries capable to cause death, which may result into 307. Means complaint under section 307 of IPC. Now see, appreciation of evidence starts from the point of lodging complaint itself. Unfortunately, I think that it is almost everywhere in India or maybe throughout the world. But when you try to complain something, you yourself or somebody surrounding to you will ask you to add something in the story. So if there was a simple injury or a abrasions only, somebody will say that you are bitten with this stick and lathi and daria and some dangerous weapon. Give name of dangerous weapon, and let us say that there is they may have killed me. This aggregation means adding something in the incident. This point starts to think about appreciation of evidence. So though something is not happened, you are trying to exaggerate your story by saying that you are beating with dangerous weapon. Similarly, the other drawback of our human mentality is to add more accused. If 3-4 persons are there, our friend or relatives or surrounding neighbors, they will advise us. The complainant means the complainant, the victim, that give name of everybody so that they may go to jail. So when there were 3, 4, or 5 persons, he was disclosing the name of 10 persons. Now, this is again a place to appreciate that what is evidence and what is not. See, it is simple thing. It's a human nature to exaggerate something, to say more injuries, more serious or dangerous injuries, or to say more persons so that they may be arrested and sent behind the bar. But now realize what happens. So a complainant, a victim, has lodged a complaint by exaggerating 3 things. 1, number of persons. Actual persons were 3, 4, or 5. He said 7, 8, or 10 persons. Well, whatever he recollect. There were only simple injuries. He tried to make a show that he was seriously injured. He was injured on his head and he was unconscious for some time, this and that. And though there was no deadly weapons available in the hands of the accused, he said that they have daria or knife or sword and some such dangerous weapons. Fortunately, gun was not said. In fact, this is a case handled by me as an advocate. I was advocate for the accused. Now see how this aggregation, which is part of appreciation of evidence, helps the accused to get acquittal. And non-appreciation by investigating officer on the day of filing complaint, and non-appreciation of evidence by police prosecutor, public prosecutor while leading the evidence result into acquittal. Look, what I have to do, I have prepared a simple chart, a table, X and Y. On X side, name of accused, on Y side, name of weapon. Stick, lathi, daria, sword, this, that, pipe. Now, in a statement of all the witnesses, police says, because practically accused doesn't have all such weapons except some lathis in hand of 1 or 2 person. But police and the witnesses and the complainant has planted the weapons in the hands of the accused who were also not present at the place of incident. And stereotype statement was recorded by the police. Now witnesses are not much aware that in whose hand sword was shown in the statement, or in whose hand pipe is disclosed, and in whose hand lathi is disclosed. During cross-examination, advocate for the accused is free to ask anything in any manner. It is a different subject how to cross-examine a witness or how to lead an evidence. But an advocate of the accused is free to even put a suggestive question. So my labor, my duty was very simple. I have simply suggested different weapon in the hands of different accused to different witnesses. And another first table according to police statements, and another table after evidence of all the witnesses, makes it clear that every witness has said that at least one witness has said that X has a sword, Y has a pipe, and if we make a table of all the deposition of all the witnesses, the result is that every different witness has said the sword is in hand of different accused, lathi is on a hand of different accused, pipe is in the hands of different accused. So practically every accused has all the weapons and has one simple thing, that a particular accused has just catch hold on the victim, means he doesn't have a weapon in his hand, and witness say yes. So practically after the deposition of all the witnesses, the scenario was that this grouping together of a relevant statement makes it a scenario that every accused has every weapon, and every accused has no weapon. So whether is it possible that accused may have more than one weapon at a time in hand, more than two? At least one is enough, but more than two is not possible. And witnesses said that yes, A witness has said that yes, X accused has a sword. B witness has said that yes, X accused has a lathi in his hand. C witness has said that yes, accused X has a daria in his hand. So different weapons were said by different witnesses in the hands of same accused. And ultimately, after appreciation of those grouping together, critical evidence grouping together, the scenario was that there was no weapon in hand of any of the accused, or there is all the weapon in the hands of all the accused. And therefore, court has to appreciate the evidence to say that all the witnesses are bluffing before the court, they are lying, they don't know, and therefore accused were, instead of conviction, acquitted, though there was an incident. So this is appreciation of evidence from day one, lodging FIR till judgment. And therefore it is a skill of picking up various pieces of evidence on a particular disputed point. And judge has to make a clear picture for assessing the worth, value, and quality of a particular piece of evidence. So what facts or which evidence can be given before the court? Facts of which evidence can be given means facts in issue, means something what is to be decided by the court, what is issue before the court. Fact about those issues can be laid before the court. Any fact from which, either by itself or in connection with other facts, the existence, nature, or extent of any right, liability, or disability, or involvement of asserted or denied in any suit or criminal proceeding. It is a fact in issue. So this, because if irrelevant story is disclosed in a FIR or in a deposition by a witness, it is not material, it is not any evidence. So appreciation of evidence means, again, how to differentiate that what is fact in issue and what is extra story. So if there is a complaint about kidnapping, as I said, if there is no kidnapping at all, or if there is complaint about murder and if there is no dead body at all, then it is not a fact in issue. What is fact in issue means what is the real dispute before the court. A fact regarding existence or non-existence, nature or extent of any right, liability or disability in civil matter, or involvement and asserted or in criminal matter is fact in issue. Then what is relevant fact? one fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of the statute relating to the relevancy of facts. One simple example of relevancy of fact is Negotiable Instrument Act and presumption therein. That if you issued a check, if your check is from your bank account, means your account with your bank, and it bears your signature and endorse in favor of someone, then it is a relevant fact that these accounts are then not material. But relevant fact is check is issued to pay some amount. So check is a physical piece of paper. It is not an accounting material or anything. But relevant fact is that yes, when you issue the check, there must be some payment to be made by you to other side. So that is relevancy. This is a simple example, but so many relevancy are disclosed or provided in a certain statute. So some fact is that fact itself may not be that much material. Physical piece of paper, a check, is not material. It is a physical piece of paper. It is evidence. But material evidence is liability to pay amount. There is a liability connected with that paper. So that is relevant of fact. Then what is basic rule of evidence? Rule of proof beyond reasonable doubt. You must have heard all this terminology. First rule is rule of proof beyond reasonable doubt. Means then there is no doubt that something is there. Right now, outside there is almost 40-degree temperature. So it is a beyond reasonable doubt of proof that 40-degree temperature is there in Ahmedabad, 40 to 42 degree. Similarly, if there is a death of a person, postmortem note is there disclosing the death, reason for death, but that death, in addition to postmortem note, an inquest report, an inquest panchnama. If dead body is found, and if panchnama is made by investigating agency that this is the dead, identification is there is no issue of identification that the dead body of particular person is lying at particular place. Two witnesses has notice it and prepare a inquest report. Now, producing that inquest report and proving it on record means it is a proof beyond reasonable doubt that there is a death of a person. So there is a rule of proof beyond reasonable doubt. Then rule of probability. It may be proved, disproved, or not proved. Probability means cause of death. It is a scientific evidence by the doctor or forensic science experts that what is the cause of death. So then there is probability. It may prove particular cause, it may disprove particular cause, it may not prove anything. If there is a natural death, there is no cause of death. This cause of death to commit murder. So not proved. Cause of death is by a weapon or poison is not proved by postmortem note. So therefore there is a rule of probability. Then there is rule of presumption. As I said, so far as Negotiable Instrument Act is concerned, in criminal rule of presumption is very less, but in some cases it would be there. But in civil, more particularly in Negotiable Instrument Act, there is a provision that if check is issued by X to Y with his name, then there is reason to believe that there would be presumption that X has to pay that amount to Y. That is presumption. Y doesn't have to prove that yes, he is in debt or X is in debt of Y or something like that. Nothing is need to be proved. Existence of a negotiable instrument duly and properly signed, issued in favor of a holder of a presumption, holder of the Negotiable Instrument Act, would result into presumption. So there is a rule of presumption. In criminal cases also there would be a presumption. And if two persons is there in the room, one is holding a weapon, firearm or a deadly weapon, knife, and another is lying with some serious injuries with that same weapon, and there is either blood or forensically gunpowder of that same firearm, then there is a presumption. There may not be eyewitness, there may not be a document, but linking two things, presence and possession of a weapon by the accused at the place of incident, and dead body of a victim with having the same injuries which is possible by the weapon which is held by the accused, and there is blood stain or presence of gunpowder, same gunpowder on both the end. Then there is a presumption that who has committed murder. So there may not be eyewitness, there may not be any documentary evidence, but it is a presumption. Then one principle is falsus in uno, falsus in omnibus. It is a Latin term which means once a wrong or one thing is wrong means everything is wrong or false or lie. It is true that in past this was the principle followed by several jurisprudence, but more particularly in Britain. But now in India, this rule is not followed much. Again, I am telling you, before a couple of decades or half a century, it was relied upon. That if you prove that witness is telling lie on several things, then you can say that he's telling lie on the incident also. But I tell you, now that scenario has changed. Now several Supreme Court judgments are there which confirms that this falsus in uno, falsus in omnibus principle is not a good principle so far as Indian jurisprudence is concerned. That means if witness may not be aware about certain other facts or things, but he is aware about the facts or evidence regarding particular incident or particular issue which is before the court for decision, then his deposition for those facts needs to be relied upon, even if he is either not aware about certain other facts or even if he has said something lie or wrong about some other facts, because it is not an issue before the court. And he was not warned that what he has to disclose before the court. But before half a century or more, or before a couple of decades, this principle was followed, and therefore it is need to be understood that if somebody puts into this principle in action, we must be aware that now it is not a good law and there are several judgments on it. My written lecture on the subject has all those judgments in it. If time permits, we will go through that also. Evidence to be weighed and not to be counted. I already said this is also basic rule of evidence. That is, it is to be weighted. Its number is not material. That how much witnesses are there, how much documents are there. One or two eyewitnesses are enough. More than one is always good. But it is not necessary that there must be 3, 4, 5 or 10 eyewitnesses or documents to prove particular thing. So it is not to be counted, but it is to be weighted, that whether it is proper or not. And last is based evidence rule. It is as good as a proof beyond reasonable doubt. But based evidence rule means there is a clear cut evidence before the court to prove certain thing, which is practically scientific evidence in civil matter or even in criminal matter. So it is a best evidence rule. So these are the different rules. We have to consider these rules because we have to consider appreciation of evidence, that how it would be appreciated. These are the method of appreciation of evidence. So basic rules of appreciation of evidence is statute like Evidence Act and Code of Criminal Procedure, which laid down the basic rules for the appreciation of various evidences. It is there in these two statutes. Judiciary has also played a vital role in clarifying the rules of appreciation of evidence on point where statutes were silent. Rules of appreciation of evidence laid down by judiciary does not have universal application, needs to be applied in the light of facts and circumstances of the case. So something may be good at particular time or place, but same principle may not be good at other time or at other place or in other case. So it is to be taken care of. Each case has got a different scenario. Courts have been granted sufficient discretion in appreciation of evidences to do justice in the case pending before them. This is the crucial area, crucial issue, that ultimately whatever you produce, whatever you think is not material, what court understand or know about the particular fact or evidence so as to decide particular issue before it, that is material. And courts are granted sufficient discretion. So it may happen that for particular evidence, one judge may say that, oh, there is no evidence, acquittal is there. Whereas other judge may say that, no, this evidence is enough and let there be a conviction. This is, in fact, this is a crucial issue so far as to entire Indian jurisprudence is concerned, either it is civil or criminal. But not because I have acted as a judge, this sufficient discretion is certainly required, otherwise there would be a pressure upon the person to decide particular thing in particular manner, and in that case the investigating agency or the powerful class of the society may be able to put particular facts in particular manner before the court so as to either confirm conviction or acquittal. So irrespective of what is placed by the complainant or the investigating agency before the court, the discretion is given to court either to believe particular facts or not to believe it. There may be pros and cons to such concept, but this is the appreciation of evidence, that how a judge will appreciate. That is material. Two side issues are there on such concept. One is, as an advocate, there is a proverb, know thy judge. आपके जज को पहचानो. What is his mentality? What is required? And by following this principle, practically there is delay in dispensing with the justice. The reason is, majority of the advocates are always waiting for a judge from whom they think that decision would be in their favor. Because ultimately judges are also human beings. They come from the same society where advocates and culprits or litigants are coming. And many times by their nature or by their other body language, face expressions of their face or their previous decisions, it is known to the bar that particular judge is pro particular type of judgment, means so far as criminal jurisprudence or criminal trial is concerned, only two aspects are considered by the bar, that judge is pro conviction or pro acquittal. So if particular judge has convicted in first, second, third case after his posting in particular place, then you see there would be delay in hearing of further cases before him. Most of the advocate would try to get adjournments from that court. And if particular judge has started to acquit in a couple of cases immediately after posting at particular place, there will be a flood in his court. Everybody would like to conduct his case, would like to complete his case before that court. So this is drawback of system. But ultimately, I tell you, if this discretion is not there, there will be different type of different issues which is there in monarchy and other type of rulers. But in democracy or in as per our constitutional provisions, discretion is must, and this discretion has both pros and cons. But the positive thing of such discretion is quite clear, that if either of the party is not comfortable or is of the opinion that discretion is not used by the court properly and judiciously, then there is provision of an appeal. In given cases, in some cases, there are 4 stages of appeal: trial court, sessions court, high court, and then Supreme Court. And fortunately, our Supreme Court is taking care of all appeals also. Even it can be said that it is being a Supreme Court, it must be a constitutional court only. But in Supreme Court also, there are equal number of cases coming from the trial court or sessions court or high court, and Supreme Court is taking care. And therefore, in many cases, it may happen that conviction by trial court or high court is converted into acquittal, and vice versa. That is, acquittal by trial court and lower court might have been convicted in conviction by the Supreme Court. So, against that difficulty of selecting court having different discretion, there is provision of different appeal up to 4 stages in given cases, but it is minimum 2 stages. In some cases, only one appeal is provided before Supreme Court, but thereby at least one appeal is provided. There is not a single instance in our jurisprudence which confirms that judgment or first judgment by the first court is final and there is nothing to be done thereafter. So this is positive also, but this is basic rule of appreciation of evidence. Now, this is a staircase during which evidence is to be appreciated at different point of time, and evidence would travel from A to N, means thereby from ignorance to knowledge. As I said, appreciation of evidence means it is knowledge, understanding of evidence, not the physical evidence alone. So that understanding will travel from ignorance, means from paper or physical evidence, to knowledge. From this staircase, that is from A to N, and starts from collection of facts by complainant or the investigating agency. Then investigating agency will sequencing the facts. They will make out the case that yes, something is proper, and so on. But so far as court is concerned, find out the problems, framing the charge, then recording of evidence, then churning of evidence. As I said, that collecting similar facts from different piece of evidence, oral and documentary. It is then shifting of evidence, again, which fact is to be proved by which party, weighing of different alternatives, applying precedents, looking to probabilities, and then finding and conclusion and order. So this is a staircase. It is not a one step. There are different steps whereby ignorance would convert it to knowledge through the staircase of charge and prima facie proof. So prima facie proof and charge would convert it into knowledge after appreciation of evidence. and that is called appreciation of evidence. Because otherwise, collection of fact means physical weapon, physical paper are already there before the police. But before conviction, that paper is to travel through this staircase, and it is to be proved properly, and it is to be properly appreciated by the court. So this is the staircase of practical stages of for appreciation of evidence. In fact, this much slides has taken more than an hour. Now, actual written lecture would start, but I think that before starting a written lecture which runs into 10, 12 pages, about most of things were taken care of by me. I will show you that. Where is it? I think this Word file is would not be. Just a minute, let me try to share it.
Sure, sir.
But in any case, this entire text of the lecture, practically, it is in a not verbatim, but taking care of what I have discussed with you. So before reading that written lecture, I would prefer to have question and answer because only 15-20 minutes are there. If time permits thereafter, we will share it, and I will share the written text to the organizer. In turn, if you found it suitable, you may circulate it. I think that would be more better because now only 10-15 minutes remains. So let us start with the question and answer first.
Thank you for summarizing this whole topic in such a beautiful manner, sir. Firstly, I will take the questions that we will get in the Google form.
See, now I think now this text is visible.
Yeah, your screen is visible, sir.
So just before I start question answer, let me explain it that all these topics are taken care of. 10 topics: introduction, admission, evidentiary value of confession of accused. So what I have discussed with reference to slide so is the basics of appearance of evidence, and here there are some detailed discussion regarding that, with at given places of time at some where I think even citations are also given that what is decided at what place. If time permits, we will read it. But first, let us take question and answer. Yes.
Sure, sir. So the question of the day is that what is the role of inculpatory and exculpatory facts and evidence in a criminal trial?
Sorry, just please repeat it because I was a little bit. Yes. Well,
Yes, sir. The question is that what is the role of inculpatory and exculpatory evidences in a criminal trial?
see, the difference is quite clear and simple that if something is practically proving particular fact or incident or issue before the court or not. So if something is properly proved and if it is confirming that particular thing, that is one thing, and if it is not proving a particular thing, but it is a side evidence, is a different thing. So the basic difference while when we discuss about evidence is whether particular evidence is proving particular thing or not. Yes.
Thank you, sir. Our next question is, what can be the probable defenses in the section 42 and 50 of NDPS Act?
Uh, I tell you frankly, that would be not proper to answer on such platform. Who has asked it?
The question is asked in the Google form, sir. There is, I
No, but
understand the point that it also varies from the case to case.
no.
And
Where is the who has asked this question? Let me read it. It is there in not on a screen, na? No, okay. But
yes,
anyway,
sir.
I'm sorry. So far as particular defense in particular section would amount to legal advice, uh, and there may be difference in legal advice by different persons. So if somebody say that why it was so advised, so it is not advisable to answer such a question. It must be a conceptual basic, not related to particular act. Yes.
Yes, sir. Our next question is that what is the how can be the facts can be more impactful than the evidence?
How facts can be molded?
Impactful than the evidence.
It is always possible. As I have already said, the fact was in an example of a case given by me, which I have myself as handled as an advocate. The fact was clear that a person was temporarily kidnapped and beaten. But during cross-examination, I was able to make it out that everybody was telling lie. So I have molded their deposition by cross-examination. Though they were telling the truth, it was molded to prove that they are not telling the truth or they are not knowing the fact. This is one type of molding. The another type, it may be positive, that if something is there which directly does not prove particular fact or issue, you may put it in such a manner that it confirms or it results into presumption regarding that fact. Conceptually, I will say you, or not any by giving any practical example, that before adducing any evidence, you must read the judgments relating to such evidence. And you must realize that what is being believed by the courts during this period or in past. Considering those discussion of evidence, one should mold the evidence of witness in that format, which may not travel beyond the truth, but manner of saying, selecting the words, that may be molded. Yes.
Thank you, sir. Our next question is from Manish Acharya, advocate, and he asks that kindly enlighten us about the digital evidences like the WhatsApp messages, phone recordings, emails, and all.
Uh, it would be altogether a full session, but in simple words, nowadays any evidence through any electronic media, if properly proved before the court, it would be considered as a digital evidence, electronic evidence. It requires a certificate as provided under IT, means Information Technology Act, issued by a competent authority, that it is not tampered with and it is copied or disclosed from or confirming the original source of creating such evidence. Because the best difference or first difference in digital evidence and physical or other evidence is In all other evidence, there would be first copy, or original evidence available before the court, and all other would be considered as a secondary evidence as provided under Evidence Act. Whereas in digital evidence, every evidence produced before anybody is a secondary evidence, because original uh, uh, the participants should realize that I am equally comfortable in IT technology, because I am using computers since 1985, and I have computerized courts throughout India. The basic difference is, when a check is produced before the court, it has got a written statement on it that on production, pay an amount to Y and signature of the drawing, just like a promissory note. On demand, pay means name of the person, name of the bank, name of the drawer, amount, everything is physically written and readable by naked eye, except proper light and capacity of eye. If spectators specs are there, you can't read without specs. But that is a physical thing. But in general, a literate person can read that check, and every literate person will be able to read it without the help of any machinery or technology. Only thing required, as I said, I'm repeating it, proper light and knowledge of that language, English, Hindi, Gujarati, if it is in a different language. So that is enough. Whereas in digital evidence, when the amount is transferred through your mobile phone to some other place, or through net banking, the amount is in numeric. But are you aware that the detail of that amount passing from one instrument to other instrument is not in numeric form? The name of the account holder is there, but that is not in numeric form. It is stored in your device, means transferred from your device to the other side device electronically, means by the presence of plus or minus field in when it was magnetic fields, and nowadays when it is digital, it is in the form of 00101. Again, that 0010001 binary is again transmitted through magnetic field only in given case, but when it is Wi-Fi, it is in digital form. But it is presence or absence of electric current on devices. So now, to prove that evidence, a scientific instrument, a person who knows this technology, their presence is necessary, their involvement is necessary, and therefore IT Act provides, Information Technology Act provides, that they have to certify that yes, this information is generated from particular instrument and it is not disturbed. So this is a basic difference of digital evidence. But the digital evidence and electronic evidence will require a full sessions. There is so many things to be discussed on how to prove it, when it will be proper proof, what is the drawback, what is the necessity, or what is care is to be taken. But in any case, now digital evidence is equally a good evidence before the court, and therefore we must learn it. Yes, next.
Yeah, the next question is from Harish Chandak, advocate, and he asked that whether the court could presume that the document is genuine or forged itself without any expert examination in section 410 and 468 of the IPC.
As I already said, there is ample discretion given to the court to decide particular thing. But in past, it was with reference to the signature of the executant of the document and at the most contents of the documents. So in past, that discretion was perfectly available to the court to decide, even without the evidence of any expert, that particular signature or particular document is either signed or not signed by a particular person. But now, considering present scenario when everything is being digital or electronically, you are right. Now that discretion is not available to the court, and therefore court cannot presume anything without the absence of scientific evidence regarding existence of document. Yes? Yes?
Yes, yeah, there are no more questions for the day. The
Okay.
other questions will be discussed with you if the attendees want to discuss. Then we will share your email address and contact details if you allow us.
Oh, you can allow them, but it must not be related to any pending case before any court, because it will amount to giving an opinion on a particular matter. So question must be legal and logically without the facts of the case. Then in that case, I will certainly answer those questions
Yes, sir. We
through,
also hope that attendees will keep that in mind,
yeah,
and
because
you
otherwise
can.
it will result into giving an opinion about pending cases, which is not good.
Yes, sir. We completely understand your point. Now
Yeah.
you can go forward with your
But now
screen sharing
I think
and
hardly couple of minutes are there, so it is better because it is already 5:27. So you want me to
yeah, sir.
continue to read this, or let us stop here?
Sure, sir. You can continue.
Huh? You want to read this, but
If
it
the attendees want to know more, then they can drop their
okay,
text
okay,
in
okay,
the
okay,
chat
okay,
box.
okay,
Yeah, sir.
okay, okay. Let me then. I just stop it. Let me share it again so that they can. Uh, Now is it visible?
Yes, sir. It's visible.
Okay, okay. But how much time you want now? This is appreciation of evidence. This is index, introduction, admission. I will skip the index, but you may have a look on it. Few subjects I have selected. So far as conceptual facts are concerned, practically I have discussed it in during the slideshow. In a criminal case, a court determines the guilt of an accused on the basis of evidences produced before it. Indian Evidence Act provides the facts on which evidence can be produced before the court. It also provides admissibility and inadmissibility of evidence. Once the evidence is proved, then comes the question of evidentiary value of the evidence produced before the court. If the evidential value of the evidence against the accused are strong enough to prove the guilt of an accused beyond reasonable doubt, then only court can convict a person. Before understanding how different evidences are appreciated by court, it is necessary to understand some basic concepts of evidence, law of evidence, like what is an evidence, facts on which evidence can be given, basic rules of evidence, and appreciation of evidence. Definition of section evidence as per section 3, I have already discussed while discussing the slides. After understanding the meaning of the scope of evidence, the next concept which needs to be looked upon is about the facts of which evidence can be given. Section 5 of Indian Evidence Act provides that evidence may be given in any suit or proceedings of the existence or non-existence of every fact in issue and relevant fact. Fact in issue means any fact from which, either by itself after a fact in issue means any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows. I think this all our facts are there in slides also. Therefore, let us go to next subject, next topic, admission, because probably introduction is there in slides, so repetition is not material. So far as appreciation of evidence or evidence is concerned, admission is also equally important issue. What is admitted by the either side? It is a significant, it is a statement made orally or in writing suggesting an inference as to fact in issue or relevant fact by any of the following person: party to the proceeding, agent to party to suit, or suitor in representative suit, or party interested in subject matter, or person from whom parties have derived their interest, or person whose position is relevant, or person referred for information. So far as civil matters are concerned, there are 7 type of possible admissions by different type of persons. This is the list. And then what is the evidentiary value? Indian Evidence Act under section 31 deals with the evidential value of admission. Admission is not the conclusive proof of the matter admitted. It is good evidence against the maker, but maker not bound by it and can disprove it on the following grounds. So see the difference. Appreciation of admission, this is also connected with appreciation of evidence. Law provides that who can admit certain things, but at the same time law also provides that how to deal with the admission. All admission are not conclusive proof of the matter admitted, but maker cannot in due course cannot hostile himself, means cannot deny the same. But again, maker can also deny the fact which he admitted. He can disprove it, and reasons or instances are given. That is, it was disclosed as a mistake of fact, it was mistake of fact, or made under threat, inducement, or fraud. In case these 2 type of cases, even maker of admission can disprove or can say that it is not a good admission. Otherwise, all admissions are not conclusive proof of particular matter, but it is a good evidence. But if on the admission the other party has altered his position, then admission can't be disproved and it may be operated as an estoppel against its maker. But again, if there is admission and other side has acted upon such admission, it means if there is some commitment or something is done by somebody and other side means other side act upon it, then maker cannot deny that admission. Then he has to agree with it. Courts have been granted sufficient discretion in appreciation of evidence to do justice in the case pending before them. These rules of appreciation of evidence laid down by judiciary does not have universal application, but needs to be applied in the light of facts and circumstances of the case. Judiciary has also played a vital role in clarifying the rules of appreciation of evidence on the points where statutes were silent. Statute like Evidence Act and Code of Criminal Procedure have laid down the basic rules for appreciation of various evidences. Basic rule of appreciation of evidence. The other equally equal evidence like admission is confession. Admission means by admitting something, but confession is also admitting something, but admitting the guilt or fault of someone by himself is called confession. While as admitting particular thing means instead of denying that he is not knowing or he was not present, he witness admit particular thing. But confession must either admit in terms the offense or at any rate substantially all the facts which constitute offense. For example, if an accused person says that he had committed theft or he dishonestly, without the permission of owner of a car, took away his car, then it amounts to confession. As in both the statements, he either admitted the offense of theft expressly or all the ingredients of the offense of the theft. But then confession is by different people. So evidentiary value of confession of accused. Judicial confession to magistrate during investigation under section 164 CRPC or during trial when charges are framed is reliable evidence and it can be a sole basis of conviction. Whereas extrajudicial confession means confession to any person other than magistrate. It is a weak piece of evidence. It cannot be sole basis of conviction if proved to be voluntarily made. Retracted confession means confession made before trial begins and repudiated at trial. It's a very weak piece of evidence. It can lead to conviction if proved to be made voluntary and corroborated by an independent witnesses. So there is different type of confession and admission. I think we should stop here because now it is almost 1.5 hours. We also get tired after some. The
Thank
organizer.
you, sir. Thanks a lot.
I will forward this text to the organizer. If you think proper, you may circulate it to people because spreading knowledge is always good. Thank you.
Sure, sir. We will share the same with all the attendees. Thanks. Thank you so much, sir, for attending this session and spreading the knowledge with the students and lawyers. There are so many questions with us in our Google form, but we will either try to reply them with our own knowledge or either send you these questions on our mail.
Okay, you can send it. We'll try to answer it properly.
Thank you, sir. Thank you all the attendees for joining the session.